on the application of Andrew Boswell and the Secretary of State for Energy Security and Net Zero and others.
Yes, Ms Thompson.
My Lords, I appear for the appellant together with Miss Buono and Mr Shattuck. My learned friend Miss Grogan appears for the Secretary of State, and my learned friends Mr Philpott, King's Counsel, and Miss Tarfor appear on behalf of the interested parties.
Okay.
In terms of timing, we've agreed that I will complete my opening by 3 p.m. today, and we'll have 30 minutes to reply, and the Secretary of State and the interested parties will share the balance of that time.
Yes, well, I wonder whether that could be revisited in the light of what I'm about to say, which is that we've made ourselves familiar with all the salient papers in the case. So you can assume that we're familiar with all of that material. You won't need to introduce it factually at any length, and we can get, I hope, swiftly towards the grounds of appeal without too much tarrying over particular factual documents. Does that help you?
Yes, yes.
I'm not constraining you, and I appreciate we have got a second day if we need it, but just wonder about your 3 o'clock estimate. In the light of what I've said.
Yes, I will take the factual submissions
right.
lightly. In terms of bundles, the court should have one core bundle, one supplementary bundle, and one bundle of authorities.
Yeah.
There are 2 documents that should be on your Lordship's desk. One is an additional page from EN1, that's MPS EN1, that was emailed.
I'm not sure that's reached me anyway.
Is that the thing that came by email this morning, which has got paragraph 5.2.10?
That yes, my lord. That is 5.2.9, 5.2.10. I think we've got additional copies. It's the examining authorities report,
Right.
and that goes in to.
I don't think that's caught up with me in paper form anyway.
We have copies. And we would suggest that that is included at.
Yeah, just a second. Where's that going to? Which
In
bundle?
the supplementary bundle.
Yeah. Thank you.
At page 168A.
Sorry,
168A.
I've got a second.
At the moment, I've got 2 copies of page 66 in the original pagination. Is that what we're supposed to have?
There should be 1 page of 66 from the original pagination.
We've all been given 2 pages.
Yes, it's a very good page.
Right, so that's now 168A.
Yes, my lord.
All right.
Thank you.
And the only other point on the bundles is that the report in the case of SMEC has some problem with the pages, so we've included a further version of the report, and that's to go behind tab 4 of the authorities bundle.
Tab 4.
Tab 4.
All right, thank you for that.
In terms of the structure of my submissions, I will structure them into 4 parts. I'll first provide an overview of the appeal and the key issues raised by the case. I will then explain the legal and policy framework. I will then set out the factual background, but heeding my Lord's indication that the court is familiar with the papers. And finally, I will make submissions in respect of the 3 grounds of appeal.
Right, you are. I mean, the early parts of that can be taken briskly if you wish. It's up, obviously up to you how you do it. But we're quite keen to get, as soon as we reasonably can, to the real substance of the appeal itself.
Well, yes, my Lord. The overview seeks to highlight what the key issues are and why the case matters. So I'll give the submissions that I go on to make some shape. So 5 brief points by way of overview.
Right.
The first, this appeal involves a challenge to the Secretary of State's decision to grant a development consent order for a gas-fired power station with post-combustion carbon capture and storage. The challenge focuses on the Secretary of State's approach to the assessment of environmental impact of greenhouse gas emissions from the development on the climate for the purposes of the Infrastructure Planning Environmental Impact Assessment Regulations 2017. The assessment of the impact of greenhouse gas emissions from the development on the climate was the principal controversial issue between the parties at the examination. Both parties used guidance produced by the Institute of Environmental Management and Assessment, or IEMA, which assesses the significance of the impact of greenhouse gas emissions on the climate by reference to the alignment with the UK's trajectory to net zero. The developer, that's the interested parties in this appeal, argued that the greenhouse gas emissions from the development would have a minor adverse impact if viewed in isolation, or a beneficial significant impact if compared to the emissions from an unabated gas-fired power station. IEMA describes minor adverse impacts as ones which are fully in line with measures necessary to achieve the UK's trajectory to net zero. IEMA describes a beneficial significant impact as one which will, where the impacts are below zero and cause a reduction in atmospheric greenhouse gas concentration. In other words, the developer argued that the development would either positively help or at least be consistent with the UK's trajectory to net zero. The appellant argued that the greenhouse gas emissions from the development would have a significant adverse impact on the climate because they are locking in a significant increase of over 20 million tonnes of carbon dioxide equivalent over a 25-year period, and that this would negatively impact on the ability to achieve the 6th carbon budget targets. IEMA defines a project with a significant adverse effect as one which is locking in emissions and does not make a meaningful contribution to the UK's trajectory towards net zero, or which falls short of fully contributing to the UK's trajectory to net zero. In other words, the appellant's case was that as a result of its greenhouse gas emissions, the development was hindering the UK's trajectory towards net zero. So the impact of the development's greenhouse gas emissions on climate, including whether they aligned with the UK's net zero compatible trajectory, was a principal controversial issue between the parties. My second point is why the Secretary of State's approach to this key issue was flawed. The Secretary of State agreed with the appellant that the impact of greenhouse gas emissions on the climate should be assessed as significant adverse. But in his decision letter, he also stated that the development would help the UK achieve its net zero targets. The result is that the Secretary of State has, on the one hand, rejected the developer's arguments that greenhouse gas emissions are a minor adverse or beneficial impact in line with the UK's trajectory to net zero, but at the same time found that the development will help the UK to achieve net zero. And that tension in the reasoning in the decision letter is at the heart of this case.
Does it say help, or do they say contribute to?
This will help, will help.
Will help.
Would
Is that
help.
what you said, or is that what the Secretary of State said?
That's what the Secretary of State said. Would help is paragraph 4.11 of the decision letter. The appellant's case is that as a result, there's an internal inconsistency in the Secretary of State's reasoning, or at the very least, a failure to give reasons to explain that inconsistency on a principal controversial issue, and that this renders the Secretary of State's decision flawed. The Secretary of State's case, which the judge accepted, is that the inconsistency does not arise because the Secretary of State did not assess impact of greenhouse gas emissions by reference to the IEMA guidance. The Secretary of State's case, which the judge accepted, is that the assessment was based on a sentence, well, the volume of emissions, and a sentence in the overarching MPS for energy, that's EN1, as I refer to it, that the carbon dioxide emissions are a significant adverse impact from some types of energy infrastructure, which cannot be totally avoided. The appellant's primary case is that if the decision letter is read fairly and in the context of the evidence before the Secretary of State from the parties, it's clear that the Secretary of State's assessment was based on the IEMA guidance. If, however, the Secretary of State did not rely on IEMA and based his assessment of the significance of greenhouse gas emissions on the statement in EN1, then this also reveals a legal error. This is because paragraph 5.2.2 of EN1, properly interpreted, does not purport to provide a basis for assessing the outcome of significance of greenhouse gas emissions from a particular project for the purpose of the EIA regulations. More fundamentally, if that is what EN1 purported to do, that would not provide a lawful basis for reaching a reasoned conclusion for the purposes of Regulation 21 of the EIA regulations. And this is because a reasoned conclusion must be based on the assessment of impacts from an individual project. The outcome cannot be prescribed or assumed by planning policy. So that's the case in overview.
Yes, right. So?
I was going to explain how that fits into the grounds of appeal, but I perhaps don't need to do that if you're...
I'm not sure you do, because once you get to the grounds, you'll be doing that anyway, I think.
If I may just say then 2 points on why this matters, why these issues matter.
Yes.
Well, they matter first because the impact of greenhouse gas emissions from this development on the climate is a principal controversial issue, and the Secretary of State has simply not given a coherent explanation of his conclusion that greenhouse gas emissions of this magnitude can be both a significant adverse impact on the climate whilst positively helping achieve net zero targets. And secondly, it matters because of how the Secretary of State says he approached the assessment of significance in this case. The Secretary of State argues that he can base an assessment of significance on a statement in national planning policy that impacts from particular types of development are prescribed or are assumed to be of a particular significance, rather than on the basis of the environmental information obtained through the EIA process about the actual impacts from the individual project. This is fundamentally at odds with the purpose of the EIA regime, under which the impacts of a specific development must be assessed, not deemed, not prescribed, but actually assessed.
Yes.
I'll turn then to the legal and policy framework.
Yes.
The starting point, of course, is the Planning Act. I can take your lordships to it unless you indicate that you preferred me not to go to.
Well, this is pretty much well-trodden territory, isn't it?
So, my lords, the relevant provisions are behind tab 1 of the authorities bundle.
I don't know whether it would be helpful to you just to indicate the main stopping points along the way.
Of course. So, behind tab 1 of the authorities bundle, section 104, of course, provides that the Secretary of State must decide an application for a development consent order in accordance with the applicable national policy statement, unless he is satisfied that one of a number of factors applies. One of those factors under subsection 7 is that adverse impacts of the proposed development would outweigh its benefits. And just pausing there, we accept that the need for this development is supported by the applicable national policy statement, in particular EN1, the overarching MPS for energy, and EN2, the MPS for fossil fuel electricity generating infrastructure. However, as all parties except the Secretary of State still had to consider whether the adverse impact of the development would outweigh its benefits.
Yeah.
And then the other relevant provisions are section 116, which contains the duty to give reasons for a decision to grant or refuse a DCO, and section 118, which provides the basis for bringing this judicial review claim. I would like to take the courts briefly to the EIA regulations. I appreciate...
Just before we leave the statute, yes. I think one of the respondents makes a submission based on Spurrier in the Divisional Court, which gathers together a number of authorities, that in the DCO procedure, there cannot be a challenge to the merits of government policy.
Yes, and we make...
Is that accepted as a principle?
That's absolutely accepted as a principle. This is not, although it has been said against us, this is not a challenge to the merits of the decision. It is not a challenge to a collateral challenge to the national policy statements. It is focused on the requirement under the EIA regulations to assess, to provide an adequately reasoned conclusion on the assessment of impacts.
Thank you.
The EIA regulations are behind tab 2 of the authorities bundle. Good. I invite your lordships to turn first to page 15 of the authorities bundle. Regulation 3 defines a number of terms, including environmental information. Environmental information means the environmental statement, including any further information and representations made by anybody about the environmental effects of the development. And this is important because the Secretary of State's obligation under Regulation 21(1) is to make a reasoned conclusion on significant effects, taking into account the environmental information. If I could invite your lordships to turn to page 19. That's Regulation 4, which provides that the Secretary of State must not grant a development consent order unless an EIA compliant with the regulations has been carried out. Over the page on page 20, Regulation 5 sets out the environmental impact process, which involves the preparation of the environmental statement, public consultation, the Secretary of State then coming to a reasoned conclusion on the significant effects of the development, taking into account the environmental information, and the authority then integrating that reasoned conclusion into the decision whether or not to grant consent. Regulation 5.2 states that the EIA must identify, describe and assess in an appropriate manner, in light of each individual case, the direct and indirect effects on the environment. And then I invite your lordships to turn to page 22. Regulation 14 sets out the information which the environmental statement must include. It must include at least a description of the likely significant effects of the proposed development on the environment. That's subparagraph 2b. And I just pause there to note that in EIA terms, the term significant is a threshold question. If an effect is significant, then it requires an assessment. So to say an effect is significant adverse or significant beneficial without more, in terms of the EIA regulations, simply denotes that it's an effect that has to be assessed. It does not describe the extent or the nature of the impact on the environment. If I can invite your lordships to turn to Schedule 4, that's at page 32 of the authorities bundle. This is where we get the obligation to assess at paragraph 5, subparagraph F, the impact of the project on climate, for example, the nature and magnitude of greenhouse gas emissions. And then over the page 34, paragraph 6.
So you're looking at the top of page 32.
So it's subparagraph 5F is where the obligation for the environmental statement to include a description of likely significant effects on the environment,
Thank you.
including on climate. And then paragraph 6 of Schedule 4 states that the environmental statement must include a description of the forecasting methods or evidence used to identify and assess the significant effects on the environment, including details of difficulties encountered compiling the information and the main uncertainties involved. Then at page 24, Regulation 21 sets out the process which the Secretary of State must follow before granting development consent.
Sorry, which?
So it's page 24.
You mean 24, do you?
I do mean 24.
Sorry, we're going back.
Sorry, going backwards.
Yeah.
Regulation 5 refers to Schedule 4, which is why
understood.
I took it out of order. So under Regulation 21, the Secretary of State must examine the environmental information, which, as I noted, is defined in Regulation 3 as meaning the environmental statement and further information obtained during the consultation process about environmental effects. Subparagraph 1b, the Secretary of State must reach a reasoned conclusion on the significant effects of the proposed development, taking into account the environmental information. And then finally, it's subparagraph 1c, integrate that conclusion into the decision as to whether an order has been granted. We don't need to go to it, but Regulation 30, which is at page 26, is the regulation that contains the obligation that the Secretary of State provide a notice of the decision, including the reasoned conclusion of the Secretary of State on significant effects. So before moving on from the regulations, 3 brief points. The first relates to the nature of the obligation under the regulations, which is to identify, describe, and assess in an appropriate manner, in light of each individual case, the direct and indirect significant effects. And that's Regulation 5. It's therefore not simply enough to identify the effects. The obligation also has to assess the significance of those effects on the environment. It's also not enough to simply say that the effects are significant. That in EIA terms is simply the threshold for requiring an effect to be assessed. And the EIA regulations do not prescribe any particular terminology for describing or assessing impacts. And that's why an assessment of the impact of a particular environmental effect must be accompanied by an explanation of what the terminology adopted means and the reasoning behind those conclusions. For example, what factors were taken into account when assessing the impact on the environment. That might be the magnitude and the nature and duration of the effect. It might be the sensitivity of the receptor.
Well, we know that. I'm just having a little bit of trouble working out where this fits.
So where this fits, my lord, is if, as we say, the Secretary of State relied on the IEMA guidance when reaching the conclusion that the project would have a significant adverse effect on the environment, then we know what that meant. We know what significant adverse meant because that's explained in the guidance. However, if the Secretary of State did not rely on the IEMA guidance, then our submission is that it's unclear what is meant by the term significant adverse.
So what?
Well, we say that that's not...
I'm not being flippant.
No, we say that's not a reasoned conclusion for the purposes of the EIA regulations because it does no more than say an effect is significant without describing, identifying, describing and assessing the impact on the environment.
You would accept, wouldn't you? Forgive me for
No.
asking really basic questions. You'd accept, wouldn't you, that a description of the impact may have to be qualitative rather than quantitative?
Yes.
In some respects, we've got quantitative because we've got 20 million tonnes over the lifetime. But beyond that, whichever route you tend to use and whichever labels you use, it's going to be a qualitative assessment of impact, isn't it? Rather than a quantitative assessment of impact. My
lord, I accept that. I accept that there's no obligation to use IEMA, but there has to be some assessment of the impact on the climate. As I'll come on to show you through reference to the IEMA guidance, that's difficult because the climate, that's the receptor. How does one explain, in relative terms, different impacts on that receptor? If, to take the example that my learned friends deploy, you're looking at the impact of noise, it's not enough to say noise will be of a particular decibel level. One has to look at how that will affect different receptors. And you can do that in lots of different ways. We can do that in different ways. You might look at guidance, health guidance on how different levels affect different receptors depending on their sensitivity. It might depend on duration. It might depend on proximity. With climate, there may be different ways to do it. IEMA suggests that the impact is looked at by reference to the trajectory towards net zero, because that's an indication of the relative impact on the climate. And our case is that saying simply significant adverse without that explanation sitting behind us tells us nothing more in our EIA terms that it will have an impact that's negative. This is why in practice, across a number of different types of effects, EIA assessors often rely on appropriate industry guidance. And how to assess the impact of greenhouse gas emissions on climate for the purposes of the EIA regulations has proved challenging, because by their nature, all greenhouse gas emissions affect the global climate, however large or small. But the key goal of EIA is to assess the extent of significance and to inform the decision maker and the public so that they can look at understand the relative severity of environmental effects and then weigh them and take them into account in the decision-making balance. And IEMA provides a method for doing that. Just to repeat, it's no part of our case that the Secretary of State had to follow IEMA. However, if the Secretary of State did not, then he needed to explain what other method or criteria or benchmark he was using to describe the effects on the environment.
Where is that stated in the regulations?
We say it comes from Regulation 5, the obligation to describe, so identify, describe and assess the impact on the climate.
I just pin down the particular provision you're relying on.
So Regulation 5,
Yeah.
EIA, so that's a reference to the whole EIA process that encompasses
Yes.
the reasoned conclusion of the Secretary of State, must identify, describe and assess in an appropriate manner the direct and indirect significant effects.
Yes, and as to the appropriate manner, is that defined anywhere?
No, my lord, no. And we accept that there's a discretion, but the point is to simply say something is a significant adverse effect in EIA terms does no more than say that it's an effect that needs to be assessed. It's more than de minimis.
Well, depending on how the language is being used in the context of the decision letter.
Absolutely, my lord. And if it's been used, had this been a case where the Secretary of State has said this is a significant adverse impact by reference to the IEMA guidance, which all the parties and the examining authority relied upon, then they would not need to say more because that's explained in that. But taken alone, my submission is it's not enough to discharge this obligation.
And it is a case-specific approach that is required in light of each individual case, it seems.
Yes.
So in an appropriate manner and in light of each individual case.
So in an appropriate manner in light of each individual case.
Are you asking us to read the decision letter as if when it talks about significant adverse effect, it's doing nothing more than referring to the threshold in the EIA regulations which require an assessment of
my primary case is that the Secretary of State, when using that term, was doing so by reference to the IEMA guidance. That is how it had been assessed.
Yes, but if he wasn't,
they're
having to place some interpretation on the decision letter, are you saying it's just a reference to the threshold test in the EIA reg, as opposed to something else?
We say it's ambiguous, and that's why essentially it's a reason.
It's ambiguous because it could be referring to that and no more. Is that what you're saying?
It could be referring to that and no more. It could be referring to IEMA, and there's genuine ambiguity because the appellant genuinely thought it was a reference to his submission shortly before the decision letter, saying this is the interested parties have referred to IEMA guidance, applying the IEMA guidance, looking at the magnitude of the impact, its duration. This is a significant adverse effect.
Did I hear you say just now that, in essence, this is a reasons challenge?
My lord, yes. And I'll explain why it's an important reasons challenge. And this goes to what is required by a reasoned conclusion for the purposes of the EIA regulation. So I've made the point that a reasoned conclusion has to take into account the environmental information gathered during the EIA process. And the second is the standard of reasons required for the purposes of Regulation 21. Is that set out in South Bucks District Council and Porter, which I won't... it's not in the bundle. There are passages, the relevant passages in the bundle, but I know your lordships will be very familiar with it, but the reasons must be intelligible.
Paragraph 36.
And they must enable the reader to understand why a decision was taken on a principal controversial issue, which we say this was. And there mustn't be substantial doubt, which we say there was.
Well, a substantial doubt as to whether it conceals a public law error.
Yeah.
In terms of compliance with Regulation 21, yes.
As opposed to reasons for reason.
Yes. And as I say, and this is also made clear in South Bucks, made clear in Dover, had it been the case that the analysis of the impact on the environment was simply accepted as set out in the environmental statement or the submission of the appellant, then you wouldn't then need to necessarily go on to give further reasons. But here the Secretary of State's case is no, that was not accepted, that was not relied upon. And we say in that circumstance there is not sufficient reasoning. And briefly, and I do want to make this submission, I will take it briefly, I'm sure all your lordships are well familiar with the Supreme Court's decision, or the majority judgment of Lord Legate in Finch and Surrey County Council in the Supreme Court.
Yes.
I'll just take you briefly to the passages we say are relevant. And behind tab 16 of the authorities bundle, this really goes to the point, yes, this is in essence a reasons challenge, but why reasons really do matter in a case like this. The first passage is paragraph 3, and that's authorities bundle page 598. If I can invite your lordships to read it.
Yeah, I think you can assume that at least two members of the court are quite familiar with this decision.
I'm sure. In other words, EIA is concerned with the process of how a decision is made. It's not concerned with the outcome. It's not a merits challenge here. It's about how the decision is made and the importance that the decision is taken with full knowledge of the environmental impact. And not just in terms of the process leading up to the decision, but also in terms of the reasons which stand for the decision. And that point comes from paragraphs 152 to 153, which is at page 631 of the authorities bundle.
Yeah.
Where Lord Legate observes that because the purpose of EIA assessment is to ensure that if consent is granted, it's done so with full knowledge of environmental impacts, it's no answer to a challenge based on a failure to carry out an EIA that complies with the EIA directive to say that complying with it would have not affected the decision. And then at paragraph 151, Lord Legate goes on to observe that it may even be that social and economic factors outweigh adverse environmental impacts. So consent is given. But that, he says, Lord Legate says, just enhances the importance of such information, particularly where issues arise relating to climate change. And that's why in the EIA regulations, it's not just an obligation under Regulation 21 to reach a reasoned conclusion. There's the obligation under Regulation 30 to publish a notice after the decision's been taken, setting out those conclusions. So in summary, the purpose of the EIA regulations is both to ensure that the environmental impacts of the development on the climate are fully assessed and taken into account as part of the decision-making process.
Can I just make sure I've
Yes.
identified the two passages you were
Yes.
reading out there? Did you start at 152?
Yes, madam.
And at letter...
So it's 152. I was paraphrasing.
Yes,
I should invite your lordship.
could you just identify the text, please?
The fact, if it be the fact that information will have no influence on whether this is below G, whether the project is permitted to proceed, does not make it.
That's what I thought. Yes. Okay. And in reading into 153, is that?
And 153 is where Lord Legate goes on to make the point that even if it will be the case that social and economic factors outweigh adverse impacts on the environment, fully reasoned conclusions remain important. I'm paraphrasing. I'll read it out. But this does not avoid or reduce the need for comprehensive and high-quality information about the likely significant environmental effects of a project. If anything, it enhances the importance of such
Yes, but I think the judge below said that these passages weren't in play here because there's no dispute about the information being before the decision maker. It's how it's been handled by the decision. Have I misunderstood?
No. These passages arose in response to an argument being advanced by the local authority that they didn't need to assess the downstream effects because they wouldn't be, they would make no difference. There was nothing they could do with that information. And the point here is Lord Legate's explaining why, even if the outcomes...
But has the decision maker here committed the legal error which was being criticised?
No, absolutely not. But it's as to why the reasons for a reasoned conclusion under the EIA regulations is important. Yeah. That's the simple proposition taken from it.
Thank you.
I'm not sure that that's controversial.
No, but it explains why this matters. restate why this matters.
Yeah, right.
I can invite your lordships to close the authorities bundle for now and take up the supplementary bundle to go to the IEMA guidance. And this begins at page 100. And I appreciate your lordships are no doubt familiar with this, so I will take this quickly.
Okay.
This is page, it begins at page 100 of the supplementary authorities bundle.
Yeah, got it.
And invite your lordships first to look at page 103. In the second column, the second full paragraph, I invite your lordships to read it. That's where it explains the purpose of the guidance.
103, did you say second column?
Second column, second full paragraph, beginning through a working group facilitated.
Yeah.
So it explains the guidance as helping practitioners to assess significance of impacts of greenhouse gas emissions on the climate. It also makes clear it's not prescriptive, you don't have to follow it, it's guidance. And then in box 1, on the same page with the first column, I can invite your lordships to read the second paragraph, which explains the approach the guidance suggests is taken to assessing significance.
Yes.
And then move to section 6 at page 114. And this is the section which sets out the guidance on assessing significance of greenhouse gas emissions. And I'd invite your lordships to read on page 115, starting in the final paragraph of the first column, the key goal, and then reading the first paragraph of the second column.
So, 115 and then...
So it's 115, a key goal, first column, final paragraph, a key goal of the IA is to inform the decision maker.
Yes.
And then the crux of significance, therefore, is not.
I've also noted in the first column, the first paragraph, it's important to note that, and then A in the middle, a continuing but over time reduced level of GHG emissions is compatible, etc., etc. And then B, the necessary level and rate of GHG emission reduction will be unevenly distributed across different sectors. And net zero will include some activities with net negative emissions and some with residual emissions greater than zero. Is that perhaps relevant to this case?
Well, we can see when we look over the page how that then tracks into what the IEMA suggests is used in terms of significance.
So it may be relevant.
But, well, yes, it is, and because it gives different levels terminology to define how residual emissions can be a minor adverse impact that's compatible with the trajectory to net zero, which is the case that the interested parties have advanced. So the IEMA guidance here is making the point that all greenhouse gas emissions are in one sense significant, as they will all impact the climate, my Lord's observation, but therefore it's essential to identify an additional factor or context beyond the magnitude of emissions to enable evaluation of their actual impacts on the climate. And then,
sorry, are you reading from your notes or from the guidance?
I'm making a submission on those two paragraphs as to what the IEMA guidance is seeking to do here, saying give some meaning to the impact on the climate, to assessing the impact of emissions on the climate. 6.3 at the bottom of the page on page 115 explains that figure 5 illustrates how to determine significance depending on the project's whole life greenhouse gas emissions and how they align with the trajectory to net zero. and I think probably the most useful place to pick the different terminology that IEMA offers is set out at page 116, but also summarised in the box at page 117.
So what are you asking us to read?
I would invite the court to read page 116. It's probably the best place to take it.
Right.
So this is where the IEMA significance terminology is set out.
Right. Well, now let's just pause. It helps the court most, perhaps, sometimes for the submission to be made first, and then any reference to support it given afterwards. So the submission here is what exactly?
The submission is that IEMA defines a significant adverse impact as one which is either not mitigated or only compliant with the due minimum standards set through regulation and does not provide further reductions required by existing local and national policy projects. A project with major adverse effects is locking in emissions and does not make a meaningful contribution to the UK's trajectory towards net zero, or significant moderate adverse, the project's greenhouse gas emissions are partially mitigated.
What you're giving us now is a précis or
yes,
quotation of the text.
So the way
what I was inviting you to do was to give us the submission.
So, if we are correct that the Secretary of State's assessment of significant adverse was based on, by reference to the IEMA guidance, which had been the basis upon which the parties to the examination had assessed significance, then it's saying that it's not compatible with, does not align with the trajectory to net zero. That's the benchmark that IEMA suggests is used for assessing the impact of emissions on the climate.
Does it matter that you're talking about significant adverse, whereas the passage you read us from IEMA is talking about major adverse?
So that's explained in the first paragraph on page 116, where it says that... on
116?
On 116 of the supplementary bundle, a project that follows a business as usual, due minimum approach, and is not compatible with the UK's net zero trajectory, results in a significant adverse effect, and then there's a differentiation between major and moderate significant adverse effects.
I wondered when I was reflecting on that proposition, reading the case beforehand, whether there is a logical necessity in the opposite formulation.
I don't...
Well, I mean, what it says is, or we can read what it says, results in a significant adverse effect. But does it follow that if one comes by a different route, or any route for that matter, to the conclusion that it is a significant adverse effect, that it necessarily, for that reason, and only for that reason, is not compatible with the trajectory? You see, there's an opposite proposition that could be tested in that way.
I think the fundamental point is that the Secretary of State needed to make clear what he meant by significant adverse, and it was assumed that he was referring to the IEMA guidance, which describes it in those terms.
So, just to help the court, if you would, what we're getting towards, I think, in your submissions is that the real fault here, as you assert it, is that the Secretary of State did not explain how she could reach the conclusion that it was significant adverse without at the same time and necessarily concluding that it was incompatible with the trajectory.
If that conclusion...
That's the core submission, isn't it?
Yeah, if and particularly if that assessment was by reference to IEMA. If it was not by reference to IEMA, then we don't understand what was meant by significant.
If she wasn't referring in that final paragraph, what is it, 7558 or whatever it is, 5, whatever, I can't remember the number, but we know the passage. If she wasn't relying on IEMA, then that problem wouldn't arise.
My Lord, if And I should say that the judge and the interested parties accept that tension arises if IEMA was relied upon, and that's part of the reason they say it wasn't. If it wasn't, then the problem is we don't know what is meant by a reasoned conclusion. And it goes further than that, because in fact what the judge held is that the assessment was based on single sentence and planning policy.
Right, so these are just, we're now, I think, isolating the two core submissions. Alternative submission 1 is reliance on IEMA, not explained, yes?
If rely on IEMA, inconsistency with the statement that this would help achieve net zero.
All right, sorry, I've packed it too densely. And then alternative 2 is if IEMA not relied on, inadequate reasons in any event.
Not a reasoned conclusion for the purposes of Regulation 21 based on the environmental
that's where it fits in the regulations.
Yes. And importantly, I think, for the broader significance of this case, the idea that you can rely on a statement in national policy that assumes or seems to prescribe the outcome of an assessment for particular developments.
With that qualification or addition, have we identified the core parts of your case?
My Lord, you have.
So, which is your primary submission?
My primary submission is that the decision the Secretary of State reached the assessment of significant adverse based on IEMA.
Okay, so that's...
And we challenge the judge's finding that the Secretary of State did not rely on IEMA.
Now, all of that said, it feels very tempting to go and look at what the Secretary of State actually said without very much more ado.
Well, my Lord, I was going to take you to the... I'll explain what I was going to do before I got to the decision letter, and you can tell me what...
I don't want to rush you at all, but I think it's important that we really get a focus on what the case is about.
Well, shall I take the court to the decision letter?
Yes.
And then, because part of the submission, a big part of the submission is, as your Lordships will be aware, the case law says you read a decision letter in the context as a whole, fairly and as a whole, and in the context of the submissions made by the parties and the evidence before the decision maker. It's an observation my Lord Holgate, Lord Justice Holgate, made in the West Cumbria case.
Well, if I may say so, at least 2 members of the court have said repeatedly that's how they pray.
Yes.
And the 3rd member has even been heard to say the same thing.
So there's no, and that's why I would have that we say that looking at the way that the impact of greenhouse gas emissions on the climate was put forward by the interested parties in the environmental statement and the appellant is relevant to how the decision letter is read, not least because I'll take the court.
Just before we leave IEMA, is it also relevant to note page 118, same section, the last paragraph, existing government policy, and in many cases define goals and necessary actions for GHG emissions reduction that is compatible with national climate commitment.
Yes.
So if the Secretary of State was relying upon EN1 for the purposes of assessing significance, might that passage of IEMA guidance be relevant?
Well, we'll come to EN1, but it's unclear how a simple recognition, as we say it is, that some types of development are supported by EN1.
You could have national policy which looks at a particular type of infrastructure need. It has to go, after all, MPSs have to go through sustainability appraisal, strategic environmental assessment. Presumably that will embrace climate change considerations. They have to go through public consultation, consideration by Parliament, etc., etc. It would be surprising if a national policy statement, for example, didn't have regard to trajectories towards net zero when putting forward policies about the need for certain types of infrastructure. Indeed, you might expect a legal challenge to the NPS if it didn't do that.
That's right, my Lord, but and EN1 is interesting because, of course, EN1 is one of the objectives is to move towards the low carbon economy, but the other objective that's pursued by it is to ensure stability and security of energy supply. And the whole paragraph 5.2.2, which is the paragraph that contains the statement that emissions from some type of development falling within the scope of EN1 will have a significant adverse effect on the environment. That makes sense only really if it's acknowledging that there will be that tension between development that's needed to secure supply, security of supply, and development that will contribute to the trajectory to net zero. And that's why it's saying it won't. The significance of that the fact that a project has negative effects from its greenhouse gas emissions on the climate won't be usually a decisive reason for refusing permission. But you wouldn't need that if they're all necessarily going to be helping achieve the net zero trajectory. I haven't put that very concisely, but that's the point. There is that there's nothing in EM1 that says that every type of infrastructure it will positively help achieve net zero. I don't think anyone suggested that's the case. Otherwise, you wouldn't need paragraph 5.2.2 at all.
Right. Thank you.
Yes.
So I will go to the decision letter and then explain why some of the background leading up to the decision letter is relevant.
Yes.
The decision letter is at core bundle 409.
Right.
So sections 1 to 3 set out the procedural background, summarise the decision. Paragraph 3.1, which is on page 413, makes clear that this is says the letter is a statement of reasons for the purposes of section 116 of the Planning Act and the notice and statement required by regulation 31(2)(c) of the IA regulations. And then paragraph 3.3 explains that the letter is intended to be read alongside the examining authority's report, and unless specifically stated, the Secretary of State disagrees with the examining authority's conclusions and recommendations. Any perceived difference should not be inferred as conveying disagreement. Paragraphs 1.4 to 4.1 to 4.9 set out the legal and policy context. And then
Do you criticise anything there?
No, my lord.
Right.
If I can pick it up at paragraph 4.11,
Yes.
this is where the Secretary of State refers to need by reference to EN1 and EN4. I invite your lordships to read that paragraph.
Well, I think we'll have
Read
read
it.
that. Do you criticise anything said
No,
there?
this is one of the statements.
I mean, the need is accepted.
The need's accepted, but this is one of the passages that contains the statement that this development would help deliver the government's net zero commitment by 2050. Then paragraphs 4.12 to 4.15 address the scope, the project, consider alternatives. And then over the page at page 421 of the core bundle, this is where the Secretary of State's conclusions on need are set out. Again, they're not criticised.
So this is 429 and following.
429 and 430. And there is the statement in 430, the second statement, that the development would support the UK's transition towards the net zero target.
Yes, all right.
Then climate change is addressed at paragraph 4.31 to 4.58. So paragraph 4.3.3, this is where the Secretary of State summarises the applicant's conclusion that the operation of the proposed development would have a minor adverse impact on climate. Notes that there was an initial omission of assessing upstream and downstream methane emissions. This led to an increase in the overall magnitude of greenhouse gas emissions from the development, but it did not, the penultimate sentence says, change the applicant's assessment on the conclusion of the significant effects. Refers to the fact the examining authority was satisfied the assessment was appropriate. So there, just to note that that terminology, minor adverse, is the terminology of the IEMA guidance. At paragraph 4.34, it's a long paragraph.
The 4.32 is where IEMA is expressly referred to.
Yes.
But that's in a different context, as I understand it, to do with resilience.
Yes.
Bearing in mind this is a coastal location.
Yeah, there are two requirements in the EIA regulations: look at the impact on climate and also in terms of resilience to climate change.
Thank you.
Paragraph 4.3.4, the first half of the paragraph relates to an issue. It was a point in issue between the parties about emissions factors. It's not relevant for our purposes, so if we could invite the court to pick it up just over halfway down. Mm-hmm. In respect of greenhouse gas emissions, the applicants again referenced the IEMA guidance. The examining authority noted that it's not disputed by the interested parties. That's a reference to the interested parties to the examination, not to this appeal, that this is a suitable approach, and was content that the guidance is appropriate for addressing the requirements of the environmental statement. And then there's further discussion of emissions factors, and at the end, final sentence of paragraph 4.34, the Secretary of State agrees with the examining authority.
Yeah.
Paragraph 4.35 refers to the applicant's revised environmental statement and notes that the applicant assessed emissions as being both significant and beneficial. Again,
sorry, I'm so sorry to take us back, but there is maybe some controversy about the last sentence of 434, I think, as to what the Secretary of State is actually agreeing with the examining authority about. Is that right? Well, perhaps just to get straight to the point, what do you say the Secretary of State is agreeing with in that sentence?
Well, we say this is the Secretary of State agreeing with the examining authority's conclusion that the IEMA guidance used by the applicant to assess significance was an appropriate approach.
I'm just getting slightly lost here because I'm going back through 434. I'm just wondering whether this is dealing with, so far as IEMA is concerned, with Chapter 5 rather than Chapter 6. In other words, it's looking at the way you go through the 6 stages, and that's why it's talking about the intensity of the emissions and so on, and also the important issue as to whether you do a whole life cycle assessment. I say that in part because you've got to read this material in light of the cross-references, and there's a cross-reference to the examining authority's report in the middle of that paragraph, 5332, which I turn up at supplemental bundle page 180, and that's dealing with your client's consultants' contentions with regard to whole life cycle. Yes. It's not dealing with the next stage, once you've got all the data and then you go on to express an evaluative judgment about the quotes significance or otherwise.
Yes, yes, my lord. Then the sentence that comes after the reference to paragraph 5.3.32 in respect of greenhouse gas emissions, they reference the IEMA guidance.
Yes, but it's in that context.
There's a reference to paragraph 5.3.44,
yes,
which is at page 182 of the bundle, and that's a reference to the applicant's approach to using the IEMA guidance to assess significance of impacts of greenhouse gas emissions.
So this might come down to what 5344 is saying.
It might, yes.
Insofar as the Secretary of State cross-refers to that.
Yes, but I mean, we've got the point made at paragraph 3.3 that unless the Secretary of State expressly disagrees with the approach taken by the examining authorities, taken to agree with it. So in a way, we don't need the final sentence of paragraph 4.3.4. If the examining authorities, the judge found, relied on IEMA then it was incumbent on the Secretary of State to say clearly in the letter.
But again, if you go on to read the rest of 5344, it's almost like a Finch argument. It's dealing with what you include in the appraisal emissions. You see, if you go back to 5343, that deals with resilience again, which we touched on a moment ago, flood risk and so on and so forth, coastal location. And then 5344, because there was a real debate, wasn't there, during the process about whether upstream and downstream emissions had been improperly omitted.
Well,
so that seems to be focusing on that.
Well, my submission is that there was a general endorsement in the examining authority's report of the use of the IEMA guidance. If I had the opportunity, and your Lordships indulge me in taking you back to the environmental statement that this refers to, the whole assessment, including the assessment of significance of impacts on the climate, was by reference to the IEMA guidance. It's not just used in order to decide whether or not to assess upstream submissions. It was not just used to look at resilience.
I think that's common ground. It's a matter of fact, isn't it? I don't think there's any dispute about it.
And having on the with that evidence before the examining authority, with that evidence before the Secretary of State, the simple submission is, if the Secretary of State was not going to adopt that terminology, having referred to the actual IEMA terminology in the letter, the fact that it was described as minor adverse or beneficial significant by the applicants, and depart from it, then the Secretary of State should have made that clear and said so.
Anyway, I wonder if we could, do you mind just coming back to the question I asked? Which
said in that paragraph, which includes the reference back to paragraphs 5.3.
So you say the last sentence refers to all the cross-references preceding in the same paragraph.
But even if that's unclear, it doesn't matter, because we know the Secretary of State says in paragraph 3.3 that it is the Secretary of State is to be taken to agree with what's said in the examining authority's report unless he expressly says the contrary.
Right.
Paragraph 4.3.5, that's again a reference to the revised greenhouse gas assessment. That's the revised environmental statement, and the conclusion that it was assessed as being both significant and beneficial. I appreciate your Lordships have read this. I won't go through it, but it's where the Secretary of State sets out his agreement that the development would emit over 20 million tonnes of carbon dioxide equivalent, and in disagreement with the developer, says that unmitigated emissions would not be an appropriate comparator. So that's a rejection of the assessment of significance put forward by the applicants.
When at the penultimate line of 4.35, it's a reference to significant adverse impact. Do you submit that that's an IEMA significant impact, or some more freestanding, freewheeling impact? Use of the phrase.
So that's a reference to the use of the term in national policy, and we say that that's just that's not. There's nothing in national policy which suggests that that's by reference to the IEMA terminology.
No, but it's a specific reference, isn't it, to the designated EN1?
Yes, it is, and it's referring to that the sentence which I've not yet taken the court to in EN1, which says that emissions from some types of development falling under EN1 are significant adverse. And that's what the Secretary of State says the assessment of significance was based upon, which is our alternative argument that that's not a proper basis for assessing significance.
I mean, that's, if you come all the way through, and we're going to reach it, of course, eventually, 458. That's parallel, isn't it, to the reference to in the middle of that paragraph, to the 2011 and 2024 designated NPSs?
Yes.
And that thread is there, is it?
That thread is there, but we say there's another thread, which is the reference back to the competing submissions from the parties and the examining authorities report.
Yeah, well, we mustn't leap too far ahead too fast.
Paragraph 4.36, there's a reference to IEMA considering that all greenhouse gas emissions are classed as having the potential to be significant as all emissions contribute to climate change. Then there's a reference to the examining authorities' conclusion.
Well, this may be significant because that takes us back to 5346 of the examining authority, page 183 of the supplemental bundle. And in the middle of that paragraph, they quote IEMA in chapter 6, all GHG emissions are classed as having the potential, etc. But as you've submitted, what the new IEMA guidance does is adopt a more nuanced approach to try and tease out degrees of significance. But I'm just wondering, as I read through the examining authority, where did they go on to apply that more subtle guidance on degrees of significance?
We do not.
Just to be clear, my lord, what that is setting out in 5346 is not in fact a quotation from IEMA. It's a quotation of the way that what IEMA has said is set out in the documents that are then referred to.
In somebody else's paraphrase.
In the applicant's...
But even so, the simple point is it's referring to a generalised statement in IEMA, or a summary of what IEMA said, and not the page 116 differentiation that you took us to.
My lord, just to complete the picture, the documents to which it refers are the original assessments undertaken by the applicant based on the 2017 IEMA guidance, not the most recent.
Be that as it may, my question is, where is the more sophisticated differentiation of significance, page 116 of the IEMA guidance, applied by the panel?
So, the short answer is neither the examining authorities report nor the decision letter say...
Well, I'm asking about the panel.
Well, neither say that these are the 5 different...
Well, it may be that what the panel were doing was to pick up the thrust of national policy.
Well,
and that's what the Secretary of State is reacting to.
Well, it would nonetheless be my submission that when you look at how these competing cases were put by the parties on this issue, which was by IEMA, you have the examining authority and the Secretary of State saying that's an entirely appropriate approach to assessing significance. It was incumbent on the Secretary of State, if who's going to depart from that approach to assessing significance, to say so. Otherwise, there's a distinct lack of clarity as to what is meant by significant adverse. So if we pick this up at paragraph 4.48, which is page 427 of the bundle, this is where you have a reference to a submission from the appellant dated the 6th of September, in which the appellant argued that the developer's revised assessment is flawed because it uses an inappropriate baseline and because of what was described as a double counting error. And at the end of that sentence, the Secretary of State agrees with the claimant's analysis of the figures and finds that the presentation of greenhouse gas emissions in the greenhouse gas assessment is incorrect. And the reference to this post-examination exchange between the developer and the appellant is important because, and I will take the court briefly to it, but what it shows is that there was a real dispute about the appropriate comparator and therefore the magnitude of emissions from this development, and consequently how applying the nuanced IEMA criteria from the 2020 guidance, the impact of those emissions should be assessed. and competing, in a nutshell, here we have the Secretary of State accepting the appellant's analysis, lifting from the appellant's submission a table which sets out what the Secretary of State accepts as the correct assessment of the whole life greenhouse gas emissions from the development over 20 million tonnes carbon dioxide equivalent.
With no comparison with CCGT.
With that, yes, that was rejected. But that was the basis upon which the applicant said, look, this is at the very least a minor adverse, but they say beneficial significant development in terms of its impact on net
Because
zero.
it'd be better than CCGT without CCUS.
Yes, but that's rejected by the Secretary of State. The Secretary of State says significant adverse, which is what and I'll take the court to where the appellant in its post-examination submission says, using IEMA, once you assess the emissions correctly and apply the IEMA guidance, this is a significant adverse impact because of its impact on the ability on the net zero trajectory. And if the Secretary of State was going to, on the one hand, accept the analysis of the magnitude of emissions, reject the applicant's assessment or argument that it was a beneficial impact or minor adverse impact, and use the terminology that the appellant was using to say it was a significant adverse impact, but means something different, then the Secretary of State should have said so. Otherwise, you have a real lack of clarity as to what was decided on that key issue.
And do you accept that one has to read all of this together, of course, and realistically, and that one should be striving, where reasonably possible, to make sense of it rather than the opposite? Absolutely.
And I won't go through the whole letter, but a lot of this is discussing that exchange between the applicant and the appellant on this controversial issue. And indeed, to take the court to paragraph 4.58, where the conclusion is set out, the first sentence, just before the Secretary of State sets out his conclusion on the impact as being significant adverse, he says he's considered the examining authority's report and the consultation responses received. She considers the proposed development would support the UK's transition to a low-carbon economy. The Secretary of State has considered the potential benefits of the wider NZT project, but accepts...
Right. Well, just again, doing perhaps what I said one shouldn't do too much, but just taking that second sentence, she considers that the proposed development would support the UK's transition towards a low-carbon economy. Could that sensibly be read as compatible with what IEMA says?
Not if, in terms of the specific development, not if you use the definition of significant adverse from IEMA.
So what is the signal one's getting there, do you say?
Well, we say, and this is our first ground, that that's an inconsistency that needed, that either it's an internal inconsistency that's a logic or it needed to be explained.
But inconsistent with what?
that if significant adverse effect has the meaning given to it by IEMA, which is not compatible with the trajectory to net zero.
I'm sorry, that's the circularity. We're approaching this in a fair-minded and neutral fashion. And we start with that second sentence. If that's not compatible with what IEMA says, then is it not the signal that's clearly being given to us by the Secretary of State that she's not applying IEMA?
In that case, we say because not just the impact on the environment, but whether the emissions are compatible with the trajectory to net zero was a controversial issue between the parties. Both advanced competing cases. In the decision letter, we have the Secretary of State on the one hand accepting, on the face of it, the appellant's case that this is a significant adverse impact, but rejecting the appellant's argument that that means does not align with the trajectory to net zero, but not explaining that.
Leave aside for a moment IEMA. Okay.
Yes.
And looking at 458, do you accept that there was material upon which the Secretary of State was entitled to reach a conclusion that the proposed development would support UK transition?
Well, I can't give a clear answer to
Why
that
not?
because I don't. Because it's what we do accept is that the need for the development is supported by the energy MPSs, including EN1 and EN2.
Well, that sounds to me like an acceptance that the Secretary of State could properly consider that the proposed development would support the transition.
Well, EN1, as I mentioned previously, EN1 has two objectives: to move towards a low carbon economy, but also to ensure security of supply. So it can support infrastructure, including unabated fossil fuel power generation, that in terms of the emissions, unabated emissions, might not positively help achieve net zero, because it's pursuing those twin objectives.
I understand. I think I understand that. But I think I also understand that there's a wealth of material in the papers which we've read, and probably in material that we haven't yet read, which supports a conclusion. Leave aside your argument about inconsistency. Supports a conclusion and entitles the Secretary of State to reach a conclusion that the proposed development would support the UK's transition towards a low carbon economy. Now, if that is and you don't challenge it on a rationality basis, so you've just got an absolutely clear statement which is not challenged on a rationality basis and is inconsistent, clearly inconsistent, with application of the IEMA guidelines in the way you say. Isn't the fair response to that to say, well, she's clearly not applying the IEMA guidelines?
And
what am I missing?
Well, in the EIA terms, what's the obligation? The obligation is to reach a reasoned conclusion on the impacts of this on the environment by reference to the environmental information, which is the environmental statement and any consultation responses in relation to that. That's referred to in the first sentence of paragraph 4.58. It is highly unusual, to say the least, to simply set out a conclusion on significant on the impacts of an effect on the environment without saying that you're not going to adopt the analysis, the method, the assessment that was used during the AIA process to carry out that assessment. And that's where we come to the alternative ground. If the judge was right and the Secretary of State is correct, that IEMA guidance wasn't the basis for this assessment, then the question is, well, what was? What did the Secretary of State mean by a significant adverse impact for the purposes of the reasoned conclusion under Regulation 21?
Thank you.
My Lords, what I might briefly do before going to and just taking the indication that you Lordships would like me to move to my submissions.
Well, yes. I mean, if that's suitable. I mean, is there anything in between 448 and 458 that you want to show us?
No,
fine.
I was going to ask about 439 on page 424, the core bundle. Because you took us to 436, but 439, EN1 suggests that operational emissions would be managed in an economy-wide manner to ensure consistency with carbon budgets, net zero, etc. Individual applications do not need to be assessed against those measures.
Yes, it's no part.
That's picked up also in the decision letter, isn't it?
At the end of the paragraph.
I'm sorry, I was looking at the decision letter, but that's derived from the report at 5353. And doesn't that feed into the Secretary of State's ultimate conclusion on climate change?
That might be a reference to paragraph 8.8.
Well, isn't it part of the journey towards, in the decision letter, to 458?
So on that point, it's not been part of our case that the Secretary of State had to assess the impact of greenhouse gas emissions against carbon budget targets or the net zero target. Again, not an obligation to rely on IEMA. The issue arises here because the Secretary of State says in terms this development would help deliver the net zero targets.
Yes, but what 439 is talking about, taking taking its cue from more than one version of national policy, is that there are some projects which don't need to be assessed against carbon budgets and so on, because they will be managed in an economy-wide manner. The latest policy cross refers to 2.4 of the 2024 document, to ensure consistency with net zero. In other words, the trajectory towards net zero.
Yeah, that you might say, look, we need to have a net emitter of a significant volume of greenhouse gas emissions over a long period of time, but that doesn't necessarily mean it's inconsistent with net zero because we can accommodate it in another way.
And we might need it because it's assisting with increasing electrification.
Yes, and we might need it to ensure stability of supply, but there's a difference between that and saying that something will positively help achieve net zero. Again, and this is coming at it from the HIEMA perspective, which is saying if this is a net emitter, it doesn't help achieve net zero. When you're looking at the actual emissions.
Have you dealt with 441? I mean, on one view of 441, this is almost a sort of pivot point where the Secretary of State is moving away from any suggestion that she's bound to apply it by reference to IEMA guidelines. And she says EXA concluded that the emissions would have a significant adverse effect even without deployment. Although quantitative data, there would be a significant adverse from the cumulative. This finding was given moderate weight because the EXA found it was found on draft policy. EXA accepted in isolation the emissions would not measurably harm the government's ability to meet national targets or have a significant effect. If that's right and that's material that the Secretary of State's entitled to take into account, doesn't that provide a complete explanation for what the Secretary of State later says?
Well, we say it doesn't explain the assessment of significant adverse.
No, but I'm dealing with your submission number 1.
No, on submission number 1, that if to reach this conclusion, bearing in mind my submission number 1 is that significant adverse is by reference to IEMA. That's just inconsistent. It needs to be explained.
But this is what I'm putting to you. I asked you previously whether there was material that supported the rationality of its conclusion that it was in accordance with NZT or however you like to describe it. And this, certainly to my eyes at the moment, looks to be another piece of information which the Secretary of State was entitled to take into account. It's reflecting a broader planning judgment, and it provides a reason why your starting point shouldn't be the paragraph which refers to IEMA, but the paragraph which states her conclusion at the end of this whole section. That's my difficulty with your submission at the moment, or it's one of my difficulties with your submission.
Well, when we're talking about the actual assessment of, and this is really what it comes down to, when you're looking at the actual emissions from this development, rather than generic statements in policy about developments of a particular type, and when the emissions evaluation is done, the assessments, the competing assessments put before the Secretary of State were compatible with net zero, not compatible with net zero. The Secretary of State accepts half of the analysis that the appellant puts forward, but on the face of it reaches an inconsistent conclusion with that. And that's the tension that we say exists. And it's not a manufactured tension. You have, as I say, the appellant making this case. Perhaps I could take your lordship, or I don't want to, there may be more in the decision letter that your lordships want to look at, where the appellant's making that case, and we say that there's no answer given to that submission in the decision letter.
Could I try something different, just for a second, just really by way of, almost as a thought experiment. If you go to paragraph 458 again, and this is the kind of counterfactual, if you like. If you put out of your mind IEMA altogether, just forget that it exists, if one can. Is there anything in 458 that is inconsistent, necessarily, with reliance by the Secretary of State there on EN1?
Well, the reference back to, first of all, the examining authority's report, which the judge said was relied on IEMA, and also the consultation responses, which, if you read that sentence...
Sorry, which sentence?
The first sentence of paragraph 4.58 is a reference back to...
Well, the Secretary of State has considered the examining authority's report and consultation responses received. Why is that inconsistent with EN?
Well, given that all of that was based on IEMA, we say that if the Secretary of State was then going to go on and say we're not going to rely on IEMA, we'll base our conclusion on the impact.
Sorry, this isn't mincing words now. When the Secretary of State says she's considered something, it doesn't mean that she's accepted everything in it, does it?
No, but this goes to the reason conclusion point. If she was not accepting the competing submissions on the alignment of the project with net zero.
Is there anything else in 458 that you say is inconsistent with reliance on EN1?
No, my lord.
Okay.
Could I go back to my Lord Justice Stuart-Smith's question about the decision letter of 441, core bundle, page 425? Because I note that towards the end, the panel accepted the emissions are not measurably harmed, etc., etc. And the cross-reference is to 5357 of the panel's report in the supplemental bundle.
185.
And by the time you get to the end of that paragraph, we're back in the territory of EN1. Clear direction of government policy towards significantly reducing GHG emissions, etc., etc. And they're looking at that when they're assessing significance, they say. So it looks, I mean, I asked you the question earlier on, is there anything in the panel's report to show they were applying Chapter 6 IEMA on significance? And you said no. And whatever the judge below said. And here we see the panel's reasoning looking at significance in the context of national policy. If I've read it correctly.
Yeah, yes. So I said that there's nothing that refers to in terms that breakdown of terminology from part 6 of the IEMA guidance. What you have in...
Well, that's, forgive me, that's the foundation for your grounds 1 and 2 in this court, that there's an inconsistency with the assessment of seeking to achieve net zero.
Ground 1, ground 2 is the inappropriate to rely on EN1 as an alternative basis.
Yes.
Submissions 1 and 2, as you called them earlier.
Yes, sorry. But anyway, coming back to the point, unless you tell me I've misread it, it looks as if it's looking at the assessment of significance not in IEMA terms, but in national policy terms.
And when you say read fairly in the context of the letter, where there's an endorsement of the reliance on the IEMA guidance to produce the environmental statement as an appropriate basis, appropriate method, if the examining authority was going to depart from that approach, it should have said so. And that's actually our ground 3, that reasons should have been given for departing from.
Well, actually, we're in a statutory framework where you can't challenge government policy expressed through, or national policy expressed through the NPS. And indeed, if you're in Section 104 territory, there's a presumption you decide the matter in accordance with. I mean, that's the starting point.
Yes, but our submission, this is our ground 2, is that this paragraph in national policy statement that's referred to, and the Secretary of State says was the basis of the assessment of significance, properly construed, doesn't purport to prescribe the significance for the purposes of EIA. It's just recognising that could be an outcome of an EIA assessment, and then goes on to say what should be done with that conclusion in terms of the planning balance. And more fundamentally, planning policy shouldn't be able to prescribe the outcome of an EIA assessment, which needs to be based on individual assessments of development. Perhaps, if there's nothing further on the decision letter, I could give the court references to the revised environmental statement and the post-examination consultation responses, and then come on to make submissions on the grounds.
Yeah. All right, so let's just tidy up a little. We're now going to the...
Well, I don't want to, if the court has read the environmental statements, has read the consultation response, I don't need
We were given many pages to read, and unhelpfully perhaps, not particular paragraphs. So if there are particular...
I will take the court then briefly, and I'll be rushed along if I'm taking too long on any of the documents.
So what are we going to look at first?
Well, in fact, we don't need to look at the revised environmental statement. I think you've got the point. All the assessment was done by reference to IEMA, by reference to the IEMA significance criteria in the 2020 guidance. And it was the applicant's case that the assessment was minor adverse or beneficial significant.
Sorry, where are you? I've got distracted. I was just wondering whether we need to look at section 7 of the decision letter.
We can certainly do that.
I'm sorry to slow people down. But,
I'm not sure. That's the section where the Secretary of State's conclusions on the planning balance are set out. It's page 482 of the core bundle.
So section 7, yes.
And 7.6 is where the Secretary of State summarises her conclusion that the volume of GHG emissions carries significant adverse effects in accordance with both the designated 2011, 2024 and draft 21 and 23 MPSs, and therefore ascribes the significant negative weight in the planning balance. And at paragraph 7.7, that weighing up the benefits and harms of the development, the benefits outweigh the harms.
there's nothing there to suggest that
Reliance
the
on
Secretary of State's assessment is that it's inconsistent with progress to net zero.
No. No, my lord. No, we say that's the problem, that there's no grappling with that tension which we say exists.
Well, it's only a tension if you say there's a tension. You don't need to grapple with it if you don't think there's a tension.
And we say it was a real tension because there's a reason the applicant strained when carrying out the environmental assessment and producing the environmental statement to characterise these emissions as beneficial, significant in IEMA terms. And in the course of that process of producing the environmental impact assessment process, starting with the original environmental statement and then through to the final submissions from the appellant, the assessment of the significance of the emissions changed significantly. The magnitude went from an assessment of 6 million tonnes of carbon dioxide equivalent over the whole lifetime of the project to over 20 million as a result of the appellant's points made by the appellant that there should be assessment of upstream and downstream emissions, that there should be inclusion of the offshore element of the project in the assessment.
Yes, but that's all, as it were, baked in, isn't it?
It is baked, because the Secretary of State accepted that, absolutely.
Yeah.
And accepted, I'm repeating myself now,
That's
but
right.
accepted the appellant's assessment that, contrary to the argument that the applicant's making, that because this is minus 32 million tonnes, because it's a net reduction when compared with an unabated gas-fired power station, therefore it's helping net zero, we've got a massive, long-term, not diminishing net emitting project, so it's significant adverse.
Yes, but there's no rationality challenge, is there? I mean, the Secretary of State has reached a judgment on that question. You say it's flawed by a failure to explain the basis upon which that assessment was adopted or accepted. The question is therefore whether that is what happened, and whether that's betrayed by a deficiency of reasons.
Yes.
I mean, it goes without saying, and perhaps one ought to say, the merits of the outcome are not up for debate here.
No, it's the reasoning that leads to the conclusion of adverse impacts on the environment.
Yeah. Well, fine. Do you want to say anything else about the decision letter before we go to the environmental statement?
No, my lord.
All right. So you're giving us some references now to the revised ES.
In the revised, so it's in the bundle, supplementary bundle
Mm-hmm.
at 141.
Yeah.
And no dispute that all the assessment is done by reference to the IEMA significance criteria that's set out at page 152 of the bundle, just for the court's reference. I'm not proposing to go to it. And that's also where you get applying the IEMA significance criteria, the applicant's assessment of significance and the impact of this project as being minor, adverse, or beneficial, significant.
Could you just give me the page reference?
Yes, of course, it's 152 of the supplementary
Sorry, thank
bundle.
you.
And you're reading where? Which paragraph?
So you've got paragraph 3.6.3 where the table is set out, and then you can see the analysis that's applied in 3.6.5, viewed in isolation, why the development would be minor adverse. And there is a reliance on the project being a net emitter, but consistent with emerging policy. And then assessed against the alternative counterfactual of an unabated fossil fuel generating station, or specifically CCGT without carbon capture and storage. It's a net reduction in emissions and therefore beneficial and significant.
Right.
So you then have the examining authorities report, and then after that, the claimant's, the appellant sends a submission dated the 6th of September that is at page 190. And it covers a range of issues which are not material to this appeal. He says that at page 207, just for the court's note, criticises the use of an unabated gas-fired.
Sorry,
Page 207.
207. And you're reading from?
So paragraph 52 through to 64.
Yeah.
There is the criticism, particularly starting at section 4.2, is the critique of the use of the unabated power station as the correct counterfactual.
Yeah.
At page 211, the submission sets out what the appellant says is the correct assessment of emissions. That's the table that we then saw is lifted and replicated in the decision letter. Where instead of minus 32 million.
All this material you would have deployed, whether you were applying IEMA guidelines or something else.
Yes, and then...
This is not going to the ground of appeal, is it?
No, so the section where...
Is this not really summarised fairly in the decision?
If I could just ask
I mean,
the court.
one understands, of course, why you'd want to ensure that we understand that this was all said, but a summary of this is surely distilled in the
Yes.
decision letter, and there's no criticism of that.
No criticism, and the Secretary of State accepts
Yeah.
the evaluation of the magnitude of emissions, that it's just
All-
under.
This
yeah.
is all accepted
Yeah.
by the Secretary.
So just the only passage I would ask you to look, your lordships to look at, not now for your note, is where the claimant, the appellant in this submission, refers to the IEMA significance criteria and explains his analysis as to why this results, the emissions, the fact that they're being locked in over a 25-year period
Right,
means
so
that this is...
that's where exactly?
Page 224 to 225,
Okay,
paragraphs 145 to 148.
right, let's just go
Sorry,
there.
224 to 5 and then...
So, and it's paragraphs 145 to 148.
Thank you.
Right.
So the comparison is with a carbon budget in 146, and it's with the NDC under the Paris Agreement in 147, so far as the electricity sector is concerned. I mean.
Yes, and it is accepted by the Secretary of State that the emissions, the volume of emissions, is just under 5% of the sixth carbon budget power sector target.
Whereas the national policy is saying those comparisons don't have to be made
They don't have to be made, but for the purposes of this
to
assessment,
assess significance.
here you have, again, repeating myself, but these competing submissions put forward by the parties about the impact of emissions on the climate, both done by reference to alignment with net zero, and we say that the Secretary of State had to grapple with that and give reasons for. The Secretary of State had to give reasons for his conclusion on that.
Maybe your argument assumes what you refer to as a tension has not in fact been resolved by national policy.
Then it should have. It needed to say. The letter needed to say so. It's my submission because this was a key issue between the parties.
But in national policies, as I understand it anyway, and I think this is actually quoted in the judge's judgment, there is project-specific support, explicit support, isn't there, for this project?
Yes.
And that's there in the NPS. But not every project receives such individual specific support.
I don't think it's in the NPS, but it is in. There is for the specific policy. I'll be correct if I'm wrong on that, but there certainly is support for it in other.
It's in the draft. What was a draft at the time?
Yes, the new. Yes, yes.
That's what I'm thinking of.
Yes.
Yes, it was a draft at the time. So, but nevertheless, there was that. That's part of the context.
It's part of the context, but of course not by reference to any assessment of the actual emissions, which is what's been done for EIA
the assessment,
purposes.
But here is the assessment. It's presented by the appellant in this court, and it's accepted by the Secretary of State, and there's no criticism of the Secretary of State's treatment of it. So what in a sense, one is going to ask what more.
Well, it's only
required.
only accepted if IEMA is relied upon. If actually the Secretary of State is reaching a conclusion of significant adverse without reference to that, then this is our ground two. What does that mean?
The contention is accepted, but what are you relying on to go further than that then in the Secretary of State's reasoning? Where does this, going back to the passages we were looking at earlier, I think 456 may be the culmination of it.
For 456 or 4?
Well, it culminates there. I think it proceeds from 448, doesn't it, and following.
Yeah.
Reasoned through, isn't it? At the moment, what is proving elusive, at least for me, is the tension to which you're referring.
The tension is if that conclusion of significant adverse, what the appellant had argued for, if that was given meaning by reference to IEMA, then the tension is between what IEMA says significant adverse means and the statements that this development would positively help achieve net zero. If it isn't an assessment by reference to IEMA, it's by reference to the statement in national policy, then that's when we have the difficulties that I referred to, that that's not what the national policy says. It doesn't purport to prescribe the effect of greenhouse gas emissions from particular developments for the purposes of EIA.
It may depend on what you mean by support the trajectory towards net zero. I mean, I can fully understand the point that some developments do not produce significant carbon emissions. A lot of the trajectory is concerned with development and encouraging wind power, solar power. But what the national policy is saying is, although those developments need to be encouraged, we can't rely upon them solely because there are times when they won't be operational or not sufficiently operational, and we need to be able to turn on other forms of electricity generation quickly, so they rely upon gas. But in one sense, according to national policy, that is supporting a greater degree of reliance upon wind and solar, because it'd be dangerous to put too many eggs in that one basket or those baskets. Isn't that supporting the trajectory?
In IEMA terms, not needed to be explained was how that magnitude of emissions, how it would impact the climate, and how a significant long-term, not diminishing volume would contribute to net zero, rather than make it more difficult to achieve net zero.
Because IEMA seem to accept that there'll be some forms of development which will be negative in the sense that they will produce carbon emissions, but they will be nonetheless compatible with the trajectory.
Yes, that was...
But what I don't understand about the diagram, and I'm sure it's my fault, on page 116, is it doesn't seem to present those projects which are compatible with the curve getting to net zero, but nonetheless have negative GHG emissions.
That I think would be the minor adverse effect that was the developer's alternative case, that if you don't compare this project with an unabated gas-fired power station, then it's nonetheless minor adverse because it aligns with government policy. And that's why we say, well, if and it is all contingent on accepting that the Secretary of State relied on IEMA. If the Secretary of State relied on IEMA and found significant adverse, that's not...
well, maybe all the Secretary of State is doing at the end of the day is to say, quantitatively, these are significant amounts of GHG emissions, 20 million tonnes. But in the same breath saying it's consistent with national policy.
We say if the Secretary of State was simply saying the emissions are of a particular magnitude without more, that's not assessing the impact on the receptor, which is the climate.
Well, it is if you're relying upon if national policy, performs that function.
But not, I mean, this is not explained in the decision letter, and left the appellant with genuinely unclear how his conclusion could have been accepted, and the applicant's rejected.
If you've got a quantitative assessment of 20 million tonnes, which is accepted by the Secretary of State, does that have to be translated into some other objective thing for the job to be done properly?
For the purposes of the EIA regulations, we would say yes, it's to use the noise comparison, to just describe noise as being of a particular decibel level without looking at the duration and the impact critically on the environmental receptor. That's not assessing the impact on the environment. That's
is this part of your challenge at this point?
Well, this is the second point, that if we're right that the Secretary of State relied on IEMA and the way that the parties, competing cases put on significance of effects, and we say accepted the appellant's case and all the reasoning that sat behind it, then nothing more is needed.
So ground 2 is really to say that there's a further problem if you read 458 and any other passages indicating a reliance on IEMA, whereas if you don't read those passages as a reliance on IEMA, the tension isn't there.
No, ground 2 says that if you don't, you're departing from the approach taken by the parties, you've not got any meaning. There's no meaning.
Can I try and understand this?
Yes.
Let's say the matter goes back to the Secretary of State for the sake of argument. I'm just wondering what happens. But the first point, presumably, is the Secretary of State is not obliged to follow IEMA.
Correct.
And could say as much. Second point, the Secretary of State is entitled, indeed is obliged to take into account national policy.
But that shall I make my submissions on ground 2? Because our point there would be, but national policy has nothing to say.
Well, I'm just trying to tease through and understand how the IA regs fall to be applied, which was my Lord's question. So we would have, shall we say, to keep things simple, for the sake of argument, the same numerical information, and there's no suggestion there's something missing. What, as a matter of law, is required in order to arrive at a decision immune from challenge to assess, to arrive at a reasoned conclusion? If you're presented with a Secretary of State says, I'm not going to apply IEMA for the following reasons, whatever. I've got this data, I've got national policy. What's the missing legal ingredient to make the decision lawful?
Yeah. So you've got to, the Secretary of State has to reach a reasoned conclusion.
Yes, what is it?
Well, it would need to explain the basis, what he says the impact of these emissions are on the environment, and he would also need to explain why he's not accepting the competing cases put forward by the parties.
So, for example, he would have to do, or she would have to do, I'm sorry,
he now.
What SET was doing in those passages you took us to a moment ago. Comparing, for example, to the carbon budget, comparing to this country's NCD.
You have to adopt a rational basis for assessing impact.
But that would illustrate
yes.
what you're advancing.
Yes.
But couldn't the Secretary of State say, I've got a policy which says that doesn't have to be done?
Well, they'd have to.
We've been through SEA for the NPS and everything. We've been through public consultation. We've got a policy. And it says that this sort of development, that comparison doesn't have to be made. Is that unlawful?
No, he would have to do something to assess the impact on the climate. He'd have to adopt some.
But that's what I was trying to understand, because it seems to me this is what the argument boils down to.
It absolutely does, and is it enough to say emissions of this magnitude, full stop? And we say no. You have to then say what the impact will be on the climate, which is difficult, and there are different ways of doing it. If you didn't want to assess it by reference to net zero targets or carbon budgets, then find another way and explain it. And that would be only challengeable on...
So he could say it's X% of the 6th carbon budget, or it's X% of the notional allowance made for the electricity sector, and it's a lot. It's significant. And then where do you go next?
And then take that...
Because he's still entitled to, presumably, to grant a consent.
Yeah, he has to weigh that in the balance, and then he is entitled to grant a consent, yes.
So what's missing in this decision letter is a comparison of the kind that SET performed.
What we say what's missing, if we're into territory where IEMA is not the basis for the assessment, is a reasoned conclusion setting out what the basis for that assessment on the impact of the climate is and what is meant by significant adverse. It's my point that it's not a term that has any meaning without the reasoning that leads to that conclusion. And in addition, and this is our ground 3, because...
what's the legal principle by which this court can dictate what a lawful reasoned conclusion would be?
It's going back to the obligation under the IA regulations.
I appreciate, yes, that has to be respected, but I'm trying to understand the court's role, constitutionally almost, in deciding what is a legitimate reasoned conclusion?
Well, it's looking at the obligation to reach a reasoned conclusion on impacts on the environment, taking into account the environmental information. If the conclusion is significant adverse, without any definition, terminology, method explaining what that means, and that's could be a broad term covering different types of impact on the climate, that's not enough. And then in addition, because of it's an obligation to give reasons, by reference to the South Bucks and Porter standard, it includes an explanation as to what the resolution was of a principal controversial issue between the parties, which here was the impact on the climate, including on the trajectory to net zero.
Well, the obligation to give reasons could be satisfied, couldn't it, by saying, well, I'm not going to decide what you've been arguing about because I'm approaching it this way, which doesn't involve IEMA guidance. I mean, as a matter of law, a decision maker is entitled to do that, isn't he or she?
Well, we say that the reasoned conclusion should have addressed that issue between the parties.
Because otherwise we would be ruling that the Secretary of State can say, I'm not going to apply IEMA guidance, but by the way, in addition, this is what I would have thought if I had been following it. I didn't quite see the sense of it.
I'm not following, it could have been, I'm not following the IEMA guidance to assess significance in this case, because I'm going to assess significance by reference to whatever the alternative basis was going to be, explaining why, and explaining, therefore, he was not going to assess the alignment of the project by reference to net zero, and he didn't, and that's not what the decision letter says. It doesn't address those arguments, those competing arguments that were put forward.
Thank you.
Just we've still got open, or at least I have, the appellant's submissions of the 6th of September 23. What was he saying the practical effect would be exactly?
Of his...
Yeah, I mean, he characterises the 148, page 225, as significant adverse and major adverse, unmitigated, serious risks to the delivery of both the UK's NDC under the Paris Agreement and the 6th carbon budget. But beyond that?
Well, he then goes on to say that this, therefore, granting permission would lead the UK to be in breach of its international obligations.
Yes, but where's he characterising what you described as the impact on the climate?
He's saying I'm not sure I followed the question. So it's starting at 145 through to 148.
Well, I'm relying on your own formulation.
It's IEMA.
What he has to do, I've written down, was to assess the impact on the climate. So where does the appellant do that for his part?
He does that in these passages by contextualising the emissions at 146.
But where's the impact on the climate dealt with?
Well, that's...
Not the impact on the Paris Agreement or the 6th carbon budget, but the impact on the climate. Where is that dealt with?
Well, the way that he's referred earlier in the submission to the AEMA guidance, which says you assess impact on the climate by reference to alignment to net zero.
The question's still the same.
So in paragraph 148, he's saying it's a significant major adverse impact on the climate using the IEMA terminology.
Forgive me, what page are you on?
Oh, this is supplementary bundle, page 225.
225.
Yes, paragraph 1.
In a sense, if I've understood this, he's using the carbon budget, the NDC, as being measures compatible with a trajectory to the net zero target. They're on the way.
Yes.
Therefore, if you take up too much of what is allowed in relation to either measure, then you're making it compatible with the trajectory.
Mm. Or to use the terminology.
But that's what the argument is.
Yes, yeah.
Well, that's the same currency as is used by the Secretary of State in 458, isn't it? But to to a different conclusion, but it's the same currency. Just look at what it said in 458.
Yes,
Same currency, but a different conclusion.
we say that there's still a tension if you're defining significant adverse in the way that the appellant did.
I'm not asking about the tension. I'm asking about the currency.
Is this so?
Anyway, you've given your answer to that, I think.
Yes, the answer is by using the metric for climate impacts in IEMA.
Right. Thank you.
In terms of, I'll make
just pause and take stock, because we've asked you a lot of questions, which has been necessary to explore your argument. But I'd like you just to reflect where you are and where you want to go next. So take a moment to do that.
Well, I think what I will do now is briefly make submissions on ground one, but this is the ground that's been discussed at some length already.
Yeah, that's fine, but you have a clear run at that, because I think that's what you'd like to do.
And ground two is a ground that I haven't really explored.
No,
and I can do it shortly, but I'll need to take the court to the relevant passage in in EN1.
So now you're going to draw together your submissions on ground one.
Yes.
Yeah.
So, in summary, the appellant's case is that the judge was wrong to conclude that the Secretary of State did not base his assessment of significance on the IEMA guidance. And we say that wasn't a conclusion that she could properly reach on the material before her. And that there is therefore an inconsistency between the conclusion that greenhouse gas emissions are a significant adverse impact and the statements in the decision letter that the development would help deliver the government's net zero commitment. So I'll take it briefly in three parts. There's the legal principles relevant to this ground, the submissions as to why the judge was wrong, and then the inconsistency point. In terms of legal principles, the first is the test for an appeal against a finding of fact. I don't propose to go to the authorities because I'm conscious that the court will be familiar with the test, but please do say if you'd like me to turn any of them up. In terms of the test, it's set out in CPR Rule 52.21, subparagraph 3, which provides that the court will allow an appeal against a finding of fact if the judge was wrong. And that's in the Authorities Bundle at tab 19, page 753.
700.
753.
Thank you.
There are two authorities in the bundle which set out the principles governing the application of that test. The Dupont de Nemours and Saint Dupont case, which is at tab 3 of the authorities bundle, and Smeck Properties and Runnymede at tab 4. I don't propose to go to them, but I'll just summarise the propositions which can be taken from those cases. The first is that review of a finding of fact will accord appropriate respect to the decision of the lower court and the decision-making process. The second is that there is a spectrum of respect depending on the nature of the decision of the lower court. At one end are decisions of primary fact based on or reached after an evaluation of oral evidence where credibility is an issue, or it concerns a purely discretionary exercise of power, and at the other end are decisions based on an analysis of documentary material. So the reference for that is Dupont de Nemours, tab 3, page 45 to 46 of the authorities bundle, at paragraph 94. The third is that where findings of fact are based solely on written evidence, also available to the Court of Appeal, the court must still consider whether the judge lacked legitimate and proper grounds to reach a decision, and so was wrong to make a finding of fact. And greater weight will be given to findings on written evidence, where the judge had particular expertise and a fuller opportunity to go into the case and understand it in the round. And that's from SMEC Properties, tab 4, page 50, at paragraphs 29 to 30. And in my submission, the present case is at one end of the spectrum. The finding on the facts that the Secretary of State did not base his assessment of significance on IEMA was not based on oral evidence, it was based on a review of the written material. And this is not a case where the judge below evaluated a larger body of evidence that's available to this court, or has greater expertise in this court, or had more time to review the material. In my submission, the SMEC authority is distinguishable, because that was a decision, an appeal against an exercise of the judge's discretion to withhold relief on the basis that the outcome would inevitably have been the same. And Lord Justice Sales, as he was, explained at paragraph 30 that that decision, that exercise of discretion, involved consideration of grounds of challenge which were not before the Court of Appeal, and deeper consideration of the case as a whole. The second point of law is the approach to reading a decision letter and adequacy of reasons. I've already alluded to these, and the authorities in the bundle. It's Mars Jones and Secretary of State for Business, Energy and Industrial Strategy, tab 6, page 125, paragraph 47. The courts must read the decision letter in good faith and as a whole. It's not the court's task to read into decisions something more coherent or less legally vulnerable than on a fair reading is contained there, but it's not for courts to strike down a decision which could have been better expressed if it's intelligible. And I just give two other references on this. State Modwin and Secretary of State for Communities, tab 7, page 138, paragraph 6. Decisions are written principally for parties who know what the issues are between them and what evidence and arguments have been deployed on those issues. In terms of my submissions on this ground, and these are developed at paragraphs 44 to 50 of the skeleton argument, which is core bundle, page 19. And there are five. I make 5 points, which in my submission show why it's clear that when paragraph 4.58 of the decision letter is read fairly, and in the context of the examining authority's report which it adopts, and in the context of the evidence and submissions put forward by the parties, that the Secretary of State's conclusion on the greenhouse gas impacts of the development was based on IEMA. The first is that all of the evidence and submissions put to the Secretary of State on the question of the significance of greenhouse gas impacts were based on the IEMA guidance and the IEMA significance criteria set out in the second version of that guidance. Bearing in mind that the first sentence of paragraph 4.58 refers in terms to those exchanges, those consultation responses, bearing in mind that the decision letter should be read in the context of the evidence put forward by the parties, particularly when it's a reasoned conclusion for the purposes of Regulation 21, which has to take into account the environmental information. And the environmental information in EIA terms is just that, the submissions put forward by the applicant and by consultees. We say read fairly, it's at the very least strongly indicative that the Secretary of State's determination was based on the IEMA guidance. The second is that the judge found in her judgment at paragraph 72 that the examining authority did rely on the IEMA guidance. And the decision letter states in terms, which would the court go to that paragraph. It's at page 94 of the core bundle.
Yeah.
second sentence, although the IPs used the IEMA guidance and this was relied upon by the examining authority.
So paragraph
72 of the
Thank you.
judgment. Page 94 of the core bundle. The decision letter at no point states that it's departing from the examining authority's approach. And on the contrary, accepts paragraph 4.58, the examining authority's conclusion on significance. And there's no appeal against this finding by the judge that the examining authority relied on IEMA. The third point is that although paragraph 4.58 of the decision letter did not refer expressly to IEMA, the decision letter made numerous references to the IEMA guidance elsewhere, including at paragraph 4.34, that's page 423 of the bundle, express agreement with the...
Sorry, can you start again? Paragraph?
Sorry, it's paragraph 4.34, page 423 of the core bundle, express agreement with the examining authority's conclusion that it was appropriate for the interested party to use the IEMA guidance to assess significance for the purposes of the environmental statement, and references to the competing, to the applicant's competing assessment that the emissions were minor, adverse and significant beneficial, which is the terminology of the IEMA
Can
guidance.
we just make sure we've pinned down which, that's a long paragraph, which sentences?
This is page
423.
Yes, it's the sentence in the middle, or the two sentences in the middle, beginning in respect of GHG emissions, with the reference back to 5.3.44, and that reference in the examining authority's report is page 182 of the supplementary bundle.
Thank you.
The fourth point, and in my submission this is a key point, is that the decision letter does not refer to any other method or criteria to explain what is meant by a significant adverse impact. That makes sense, of course, if the Secretary of State's assessment is based on the methodology that the parties were relying on, the IEMA guidance, which explains what that term means. If, however, this assessment was not based on IEMA, there's no explanation in the decision letter of what the Secretary of State means when he concludes that greenhouse gas emissions will have a significant adverse impact on the climate. It's not a defined term in the IEMA regulations.
But it is a term that's used in every single decision letter that's ever written.
Because it's, well, that or not a minor adverse effect, but always by reference to the assessment that sits beneath it.
Just on
Yes,
this point,
but
sorry, I
it's
beg
still-
your pardon. Sorry.
It's used frequently with a degree of elasticity which comes from not being specifically defined.
It's used with elasticity, and that elasticity, we say, is why it's important. That the reason, without the reasoning that sits behind it, the analysis, the factors that are taken into account when assessing significance, it's a term that is so elastic, it's got very little meaning, save that it's an effect that is more than de minimis so as to require assessment under the IA regulations.
Thank you. Sorry, I interrupted you.
No, it's my fault. At the time of the first edition of IEMA, there wasn't a definition of significance.
So in that, I can find the reference after lunch. What was
Because this was the issue raised in, I can never say the name correctly, GOSA.
GOSA.
And didn't the court decide in the High Court that it was a matter of judgment for the decision maker? I mean, there's no legal obligation to define what you mean by significant, which is really, I think, my Lord's question.
Yes, the obligation is to provide a reasoned conclusion using significant or not.
I'm sorry, I'm not interested in that. Yeah. I'm asking you about whether there's an obligation to define what is a significant adverse effect as a matter of law. whether it comes from Regulation 21 or any other source.
Well, so my submission would be that to simply say an effect is significant and adverse would not discharge the obligation under the IA regulations, because it wouldn't identify, describe and assess the impact on the environment.
If this submission is correct, every time a decision maker in an EIA case says this is a significant adverse effect, they've got to say
why.
Yes, whether it's a landscape effect, noise effect, whether it's numerical, non-numerical.
Yes, and I can see your lordship thinks considers that a surprising submission. It's actually really important, because without explaining why it's significant, because that term is, as my lord observed, elastic, it's not got the meaning necessary for it to be taken into account in the decision. It's actually really important that it's given that meaning by and that's the whole, the EIA process is designed to do just that. It's a process beginning with producing an environmental statement, consultation responses, and on the basis of that environmental information, reaching a reasoned conclusion on the significance of the effects on the environment. And this actually, I'm coming on to ground two shortly, is why it's not if you could just say that all projects of a particular type have a significant adverse effect on the environment, that would encompass within it a wide spectrum and make it very difficult for that impact to be taken into account in a meaningful way. That's not difficult, however, if you've done so by reference to taking into account the information gathered as part of the environmental process. It's why, for example, the EIA regulations, I took your lordships to paragraph 6 of Schedule 4, says it's important that it's a requirement, it's an important requirement that the environmental statement sets out the method and analysis that's used to reach an assessment, to give that meaning.
So, does that mean, and perhaps this goes back a little in the direction of the questions I was asking you earlier, does that mean that this has to be characterised, or use that word, in terms of the effect on global warming, for example, of these emissions?
That would be the obvious way to do it, because it's talking about the impact on the climate, and the impact that's adverse is the impact on global warming.
So I do not want to put words into your mouth at all, but are you saying that unless such an assessment, or unless such a conclusion were expressed, there would be a deficiency against the requirements of the regulations?
Unless a conclusion about the impact on the climate were expressed, there may be another way of doing it than referring to the impact on global warming.
Well, what was required here? This really does go back, I think, to my question, and perhaps you've already answered it, therefore. What was required here to make this sufficient?
It's an explanation of what the impact of these emissions from this development over this period of time would have on the climate, most likely by reference to, and certainly the practice is by reference to, the impact on global warming, but there may be another way of doing it.
And where was that grappled with at all, anywhere in the present process, that question? Anywhere? Where does anybody involved in this process get to grips with that question?
Well, in my submission, the parties, the applicant and the appellant, were doing that.
So, again, I don't want to repeat a question which you've covered, but would we find that in the appellant's submissions of the 6th of September 2023?
In my submission, that's what the appellant was doing by reference to IEMA in the passages at 145 to 148.
Well, it does lead back to my question then. Does he deal there with the effect on global warming of these emissions?
He's looking at it in the context of the impact on the net zero trajectory.
Yes, but that's just a trajectory, as it were. It's a hugely important one, of course, but it's a line on a graph, isn't it? your submission is that to satisfy the requirements of the regulations in this regard, there had to be some grappling with the effects on climate or global warming. And I'm asking you whether that was done by any participant in this process or indeed by the examining authority itself.
Well, in my submission, the applicant and the appellant adopting the guidance in IEMA, which says you can look at that impact on greenhouse gas, on global warmings by looking at the alignment or not with the trajectory to net zero as a proxy for that.
Well, you can do that, but my Lord's question, which has really stimulated mine, is what is required to satisfy the
There might be another way of doing it, and it's not an easy question when it comes to impact on climate. That's the starting point for the IEMA guidance. This is difficult. It's a challenge to grapple with this in the impact on climate in EIA terms.
And is there any authority that supports this proposition?
The proposition that you have to...
That you have, well, that supports your answer to my Lord's question. Is there any case in the case law that says this?
Well, my proposition is that there has to be an assessment of impact on climate, and and that just comes from the requirements of the IA regulations.
Yes, but I'm not sure you're really going that far, because impact on climate is a global phenomenon, and your expert understandably didn't go that far because he compared the GHG from this project with NDC and carbon budget, which are expressions of the UK's contribution to tackling a global problem.
Well, the question would be...
So he was content to apply the IEMA guidance in that, I'm not criticising,
No.
just trying to understand. He was content to apply the IEMA guidance in the context of looking at what the UK is doing, the UK's trajectory.
Yeah, and then the question...
UK-centric.
Yes.
And trajectory-centric rather than climate-centric, actually.
Yes.
So the question would then be, in terms of the case law and assessment of IEMA, is that a rational way, using that as a proxy for an impact of a particular effect on the environment, to assess that impact? IEMA suggests that it is a sensible way of assessing an impact on climate, because it is difficult. But my submission, if the Secretary of State was not doing that, the Secretary of State needed to do something else.
Understood. This was your fourth point.
The final point, very briefly, and then I can move on to ground two after.
Right. Well, if we just take your fifth point and final point on this sequence, and then we'll rise, I think, for the short adjournment.
The decision letter at paragraph 4.58 does not expressly state that the Secretary of State's assessment of significance is based on IEMA, but there's no statement that the Secretary of State would adopt a different basis for assessing significance than that adopted by the parties.
No basis for a different. Just say the last bit again.
No statement.
There's also no statement that the Secretary of... There's no positive statement that the Secretary of State was adopting a different basis for assessing significance.
Yep. Thank you. Thank you very much. Now, would that be a convenient moment?
It would, my lord.
Good. We'll come back at 2 o'clock. Just before we rise, how is progress going?
So I've got my submissions on ground 2, which will be short, and then even shorter on ground 3.
Right.
So I'll definitely be finished before 3 p.m, if not.
Right.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Queen's Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
Which is to come back at 2 o'clock.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Queen's Building.